Another day, another solution. Let's talk dirt. I often hear the question, Rick, is it true that after 3 years I can own land in Texas through adverse possession? If that's true, then why do we even have a 10-year statute? Why would the law require 10 years in one situation but only 3 in another? Now that should tell you something, because the 3-year rule is not meant to be easier. It's narrower, it's more technical, and it only works in very specific circumstances. Today, we're breaking down the Texas 3-year adverse possession statute, which is the shortest timeline in Texas, and why it almost never works the way people think. If you've been following this series, you already know. Adverse possession is a checklist. Actual possession, open and notorious, exclusive, hostile, and continuous. If you miss one box, your claim fails entirely. Now, the 3-year statute does not eliminate that checklist. It actually makes things harder and it makes it more demanding. Here, you're going to need a regular chain of title. Under Texas law, the 3-year statute applies when someone possesses property under color of title through a regular chain of title. This is not a fence case. This is not a we've used it forever case. This is a paper case. You must have recorded documents, and those documents must form what appears to be a legitimate chain of conveyances. Without that chain, the statute does not apply. So, what does color of title actually mean? Color of title means a written instrument that appears to convey ownership, but for some legal reason, it does not actually do so. It looks valid on its face. It looks legitimate and it's filed in the property records. But somewhere in the background, there's a defect. For example, it could be a deed from someone who mistakenly believed they owned the property. It could be a conveyance with a technical flaw, maybe a break somewhere in the historical chain. The key idea is this: you're claiming ownership under paperwork that appears legitimate, even if it later turns out that something was wrong. But that paperwork must connect through what looks like a regular chain of title. In other words, A to B, B to C, C to D. If the chain is missing links, the claim is in serious trouble. Now, let's address something important that is usually missed. In Texas, a forged deed is considered void. It's void from the beginning. It conveys nothing. The law calls that void ab initio. And because it conveys nothing, it generally cannot create a valid chain of title. That is a major issue under the 3-year statute. Remember, the statute requires possession under a regular chain of title. If your chain depends on a forged instrument, you don't just have a defect, you may have a collapse. Forgery is not the kind of defect this statute was designed to protect. The 3-year statute exists to stabilize title when there are technical flaws. It does not exist to rescue fraudulent documents. So if someone thinks they can rely on a forged deed and they can just wait out the 3 years, it's not how this works. The 3-year statute usually shows up in competing deed disputes, title defect litigation, situations involving mistaken ownership, and historical conveyancing errors. It is not common in neighbor disputes. It is not common in fence line cases. It's used when someone genuinely believes their paperwork gives them ownership and they possess the property accordingly. But even then, they still must prove actual possession, open and notorious use, exclusivity, hostility, and continuity for the full 3 years. And if the paperwork falls apart, the claim falls apart. So people often hear 3 years and they assume it must be easier than 10. But compare the burdens. Under the 10-year statute, all you have to do is prove possession for the 10 years, along with the other elements. Under the 3-year statute, you still have to prove possession and the elements plus a regular chain of title. And proving chain of title can be technical and unforgiving. A missing instrument, an improperly recorded deed, a void conveyance, any of those can end the claim. Yes, it's a shorter time period, but more precision is required. So let's go back to the question from the beginning. If 3 years were enough for everyone, why would the 10-year statute even exist? Because the 10-year statute covers possession without paper. The 3-year statute covers possession with paper, but some type of defect in the paper. They address completely different scenarios. The law isn't inconsistent, it's specific, and specificity means limits. So, friends, here's your takeaway for today. The Texas 3-year adverse possession rule is not a shortcut. It is not a fence statute. It is not a cure for forgery. It is a narrow technical rule designed for situations involving defective but structured chains of title. meaning you have a title document that has been filed for 3 years, but it has a defect. And like every adverse possession claim, miss one of the other checkboxes and the entire claim fails. In the next video, we're going to break down the 5-year statute, the one that requires a recorded deed and payment of property taxes, and why that rule has its own traps. If this series is helping you understand Texas real estate law more clearly, like the video, subscribe to our channel. These videos are for educational purposes only, and they are not meant as legal advice. If you'd like to speak with an attorney in our office, please visit us at the website in the links below. As always, thank you for watching.